Hi, Ron LeGrand here. Before we get started with the podcast, I thought you might want to know that I recently recorded a 90-minute online training about how we make so much money today in the terms business. That's on pretty houses in pretty neighborhoods, not the junk houses that we have to go rehab or wholesale. I go through step by step on exactly what I and thousands of my students are doing right now to make the fastest and the easiest money in real estate without using your money or credit. If you're interested in doing just that, go to thementorpodcast.com/free training. See you there.
Welcome to the Mentor Podcast, where the most highly motivated entrepreneurs come to get their weekly dose of financial stability with host Ron LeGrand, as well as other nationally recognized thought leaders who will teach you how to get, grow, and protect your wealth.
Well, hello, everybody. Welcome to the Mentor Podcast. This is Ron LeGrand, and I have a very special guest today. His name is Bob Bluhm. Bob is an attorney out of Texas. And we are working very closely with him now because he's doing a lot of work for a lot of our master's students, setting up their entire estate plan and protecting them from predators, but also deciding where your stuff goes after you're gone. I've been looking for years for somebody to actually do that, not just talk about it and teach it. And Bob and I were in a mastermind meeting, a little while ago, and we got to talk. We've known each other for a long time, but we got to talk, and we worked out a deal for our master's students. If you are interested in learning more about that, you can contact my office, and one of our folks will explain it to you. But basically doing the entire estate plan for you. So, Bob, I think probably I'll leave it up to you to tell everybody who you are and how important you are, because you're better qualified than I am for that.
Well, I never tell anybody how important I am, but my name is Bob Bluhm. I'm an attorney and have been for many years, and I practice asset protection, which is a field that's pretty broad in terms of attempting to lower taxes, protect from liability, and plan estates as well. So that is the broad definition of asset protection.
Okay. Now, you've been doing this for a lot of years. Work with clients all over the country.
And all over the world as well. Yes.
All over the world. Okay. So you specialize in estate planning and asset protection as a one package. Because I've often told folks, don't ever try to get these two things done with two different firms. You're going to have conflicting opinions, and you're just going to create a big mess. And also tax planning needs to be in that package as well. So I try to steer them to one firm like yours, to where you've got cohesive care. And of course, one person in your organization doesn't do all of this. It's several attorneys combined that each put their input on a specialty, which makes it a good plan. I got to tell you that I've got a lot more in my plan that I did in 2000 than you charge our clients, a lot more. That was 20 years ago. So, and I think, before I get to question you, we probably ought to make everybody aware that this is not an overnight process. Putting together an estate plan is a grueling job, because they have to answer questions that they never thought about answering before, to decide things that people just don't give much thought to, before you can go and put together the documents and prepare the plan for them based on their current situation.
That's right. And I might add, Ron, these are questions that people would really rather not think about too.
Yeah, I remember. Okay. And if we put 10 people against the wall, and no two of them will have the same exact plan, so it has to be based on what's going on in their life: married, single, children, grandchildren, no children, businesses, no businesses, assets owned, how they own, and so forth. And that's going to vary. So you are also an expert in LLCs, and we've had you on our broadcast several times talking about LLCs, and frankly, how most people think that they've got a good LLC because they go on the state site and fill in the blanks and pay the fee, and they got an LLC. So I want you to talk about the fallacies of that, and I'm guilty of that myself. We did that for years. So I want you to talk about the fallacies of that and what we can do to fix it.
Well, sure. And it's misleadingly easy to think that, because now everything is automated. You can go to a Secretary of website in any state and call up, form an LLC. It's right there online, and they ask you a few simple questions like, what's the name of the LLC and what's the address and who's the registered agent, and oftentimes that's it. In some states might want a little more information, like who's the manager and who are the members, but beyond that, that's it. You hit a button, you pay your filing fee, and boom, you get the articles of organization. Well, a lot of people think that's all it takes to protect, and yet that's just the beginning of an LLC. All the protections are in the documents that follow that, which you cannot get online, which the Secretary of State's office doesn't provide. And those are the operating agreement, there's minutes of organizational meetings and various resolutions. And that's where the protections are found as to how the money is going to be distributed to the members, under what circumstances it'll be distributed, whether a member's interest can be seized by a creditor or not. All of those things are in the operating agreement and what are called the supporting documents as well. That's where the protections are found, and that's what really gives you an LLC that's going to do the job.
Okay, so the key is, of course, the operating agreement and the language in it.
Yeah, exactly.
Not where you form the LLC. Most people just grab an operating agreement off of LegalZoom or wherever, plug in. So,
right.
Fill in, right?
Yeah.
So,
yeah.
In your case, you do LLCs.
Oh, yes.
For folks, what do you charge to do an LLC for them, and what does that entail?
Well, our normal fee, Ron, is $1,500 for an LLC. We give your people a special breaks, so I hope nobody outside of your group is hearing this, because it's only for your group. But it entails a process of consulting with the client first, finding out what kind of business they have. What are they going to do in real estate? Are they going to do wholesaling? Are they going to do flipping? Are they going to buy pretty houses? Are they going to use a land trust? There are all kinds of different LLCs that are designed different ways. And so in that consultation process, we understand what they're trying to accomplish. Do they want privacy and anonymity? Do they want, to protect their rental properties? What are they trying to do? And once we understand what they're trying to do, we can suggest an approach for that. And often it's not just one LLC; it's a structure of interlocking LLCs or corporations or limited partnerships. It's not just one tool, or trusts as well. And we put that together, and it doesn't have to be complicated. It can be simple if the situation is simple, but if someone has a little more complex situation, then it calls for different tools to be used in different combinations. So it's all customized. There's no one size fits all approach. And oftentimes we need to consult with the client several times before we finalize what really needs to be done to protect them. Okay.
What do you charge our clients for that, Bob?
Well, we charge your clients just a pittance, and that's $495 for an LLC.
Yeah.
And I don't know how long we can do that, though, Ron, because that's really a giveaway.
I was going to say that's subject to change. So
that is subject to change, and that was just so we could get to work with you and your clients.
Yeah. All right. Now, we have had a lot of discussions about LLCs. I've done a lot of teaching myself about them, combined with land trust. And of course, the key, I think, is how you own the LLCs for asset protection purposes, that is. Maybe even tax purposes as well. So let's start at the top. Now, I don't have my diagram here, but I teach everybody to take title to a house in a land trust, or a grantor revocable trust is what you should refer to it to your attorney, so that you might understand what you're talking about. By the way, if a real estate attorney doesn't understand what a grantor revocable trust is, they probably should keep looking, don't you think, Bob?
Yes. Yeah, keep looking.
Okay. So I teach them to take title into a land trust, one house, one trust, one egg, one basket. But then, and that's in any state, frankly, knowingly, you're going to get some flack if the people you're dealing with do not understand these trusts. We're going to talk to you about it, and especially attorneys. for various reasons, which to date, an attorney has not shown me any reason why not to use a land trust. They all want you to deed the properties to an LLC, and I can certainly make a case against that for asset protection, putting more than one property in one LLC. But what is your feeling about land trusts before we go any further?
Land trusts are fantastic tools if a client is looking for anonymity. It's one of the most important tools to use to create anonymity. And anonymity in and of itself doesn't protect. But think about this: when you're able to fly under the radar, because understand, I got to step back a minute. If a plaintiff's lawyer is thinking of suing you, they have the ability to go to the internet and do an asset search and discover anything you own if you own it in your personal name. And so it's an open book. And if it turns out in an asset search that you own lots of properties, then you're a great target for a lawsuit, and the plaintiff's lawyer is a whole lot more likely to sue you. On the other hand, if they do an asset search on you and it turns up nothing, and yet you own lots and lots of properties, the plaintiff's lawyer is a lot less likely to sue you, because it's going to be a whole lot harder job. And the first impression is there's nothing to collect here. This guy's broke. And so why would they want to sue someone who's broke? And so anonymity can be a very, very important protection device in that sense. All right. So land trusts help you achieve anonymity, but they also help you avoid the due on sale clause. They have, when transferring properties into an LLC out of your personal name, they do lots of other things. They can facilitate the sale of the property by selling the beneficial interest. If you wanted to sell the beneficial interest rather than just selling the property itself, and it provides excellent asset protection if and when the beneficiary is also a limited liability company and you are sued personally.
Yeah.
So
we're getting there.
all those things.
There first. All right. So land trusts give you privacy because the only place the beneficiary is known is in the trust agreement, which is in your filing cabinet, not on public record.
Exactly right. Right.
Okay. They also have, they don't die. Trusts don't die. So
that's right.
The beneficial interest in land trust can just keep on doing what they're doing after it dies. And there is ease of transfer, which a lot of people do not think about. I can just sell you my beneficial interest. Nothing changes downtown, and there's no closing costs, none whatsoever.
Right.
So the problem is, I think many attorneys, I don't know what these attorneys think, but I think they think that the land trust is an asset protection device and they can't go through that. We all know if they found out we have beneficial interest, they can get that beneficial interest, unless, of course, it is owned correctly and we don't have it. You just said we need to work really, really hard to look broke. That's what you just said.
That's right.
Absolutely true. I can tell you from my own experience, I'm broke. I don't have anything. As far as anybody's concerned, I own nothing. By my name in public record owning anything. So key is now how to own those land trusts.
That's right.
You have seen my plan with the 4 LLCs in it. So and also this depends on whether you're married and what state you live in.
That's right.
How you should own the land trust. In my case, I live in Florida. I'm married. So tenants by the entirety is one that I use a lot, and it's done very well for me, by the way. It's protected me to this point from creditors from 2008 trying to protect everything that I have. But I'm in Florida, and tenants by the entirety are honored. So if I own a land trust, you suggested we probably have those land trusts owned by an LLC if we're in a keeper entity now. We don't mix keepers and flippers. We're a keeper entity. We've got tenants in the houses. We can have as many land trusts in one LLC as we want, because the land trust is the one that's exposed, not the LLC as the owner of the land trust.
That's right. On the public record, it's the land trust that goes on the deed in the public record. And it's just the name of the trust. That's all. It could be the 521 Main Street Trust. And then you may name the trustee, in which case I like an LLC to be the trustee. So your name is not on the public record. Once again, that destroys your anonymity if you put your name as the trustee. So we use an LLC as a trustee.
Yeah. Well, and that's the case now. Some states have to have an individual as a trustee. Easy enough for you to check. And that individual just not have your last name. That's all.
That's right.
So we got the house, and we could put 10 land trusts into one LLC. And one of them does not affect the LLC. An accident on a house that's owned by a land trust has nothing to do with the owner of that land trust. It's only to do with that land trust that owns that house. So one house is at risk. Correct?
Right.
All right.
Yes.
Now, well, before I move past that, though, let's suppose I did what I've seen many attorneys do and have me deed 10 houses into one LLC. Now something happens to one of them. All 10 houses are at risk because they're all owned by the same entity.
That's right.
Something that simple, you would think that any attorney would understand clearly and not allow somebody to do if they have an asset protection mind. But that is not the advice that a lot of people get. All right. So now, this is where you're such an expert at, is how do I own this LLC? Let's start with, I happen to be in a tenants by the entirety state, and I'm married. Probably tenants by the entirety. Would you agree?
I would agree. Yes. In 26 states, we've got tenancy by the entireties, and that's a great way for a married couple to own assets. Okay.
Now, there's one big flaw in that. Right? If a judgment is against one, well, tenants by the entirety means 100% undivided interest. And the key word is undivided. Correct. You can't take part of an asset that's owned 100% by both parties. So, laws of judgment against one party, tenants by the entirety is great. Okay, if it's against both parties, you might as well.
All bets are off.
Yes.
Yep.
Which makes a real case not to have both spouses involved in any guaranteed debt or anything that could cause a judgment against both parties.
Correct.
Preach that and teach that. And most people just don't understand that when you go to a bank to get a loan, against my wishes, of course, both parties do not have to guarantee the debt if one party can qualify, but the bank is never, ever, ever going to tell you that.
You're right. Exactly.
So
and you know what, Ron, that's good practical advice. That comes only from someone who's done it for years and years like you. It's not necessarily legal advice. It's practical advice. Here's how you go to the bank. Here's how you apply for the loan.
So if you can qualify, there's no need for the other one to sign. Now, both will have to sign the mortgage, but the mortgage does not create debt. The mortgage doesn't create liability. No,
that's right.
You don't want to sign because that's what they'll come after you on. So
exactly.
Do everything we can to keep one spouse out of harm's way. And I'm careful here because it could be the wife running the business and my husband not. Either way. I've done everything I can to keep my wife out of harm's way all these years. And all the crap that I've been through, it's a good thing that I did that. So I just don't sign any notes or anything else for that matter. And then there's the case of are both parties operating the business? Are both parties putting themselves out there to be liable in case of an accident or something, which is something that I probably should have a discussion with you about or their attorney. Because if they're both practitioners in the business and something happens, then they can come after both of them. Am I on the right track there?
Correct. Right.
So one needs to be in the background, not actively participating in the process of buying and selling and renting that the public communicates with. In other words, if something happens in a house, you're probably going to sue the person that put that tenant in the house in many cases. So that person should be the one that's accepting the liability risk, not the one that you're trying to keep.
Right. And that could be just one of the individuals as the manager of the LLC, the other is a passive member of the LLC, or you could use a management company as the manager of the LLC, and that keeps both of you out of harm's way. Okay. So a management company is part of one of the four structures that you often talk about. And that's
but even then, isn't the person at risk that actually took the money from the tenant, made the promises to the tenant?
Well, it's the person it's the person who might be guilty of negligence. So, in other words, if the manager was notified of the creaky steps that should be repaired, these steps are not safe, and does nothing to repair the steps, and then there's a slip and fall on those steps. Well, then that manager, that individual or entity is the liable party because they knew or should have known of the harm.
All right, so now that brings me to the next point. First of all, in the world of litigation, it's not about trying to hide stuff.
Right.
You guys are too smart for me to hide stuff, aren't you? I tell you what, ever since Al Gore invented the internet, it's been hard to keep it. So it's not about hiding it. It's about making sure that the predators can't get it even when they know you've got it.
Right.
That all comes back to how you own it. All right.
Correct.
You started with land trusts, which are not going to protect you if they find out you have a beneficial interest, because they give all those other benefits. Land trusts are owned by LLC. Now, LLC is either owned by tenants by the entirety, or if I'm not married, or if I'm not a state, use the TBE, then you suggest we own it how?
Well, then we can own it in a holding company, which is probably the next safest thing after tenancy by the entireties. A holding company would be set up in a state that has very strong liability laws. Florida happens to be one of those states, Ron, but also Delaware, Nevada, and Wyoming are the leading other states with very strong lawsuit protection laws. We would want to set up the holding company in one of those states in order to own the LLC. That gives a lot of benefits. One is tax benefits, because now if the holding company owns the LLC, it becomes a single member LLC, and it is not required to file a federal tax return, which could save tax preparation expenses.
All right, well, that's the first time I've heard you say that. That would have to require some further exploration, from my point of view. But what I thought you were going to say is a limited partnership, which is also a way to own those LLCs. And we'll go ahead and explain that. Limited partnership.
As a limited partnership? Yeah, and that would be the same thing as a holding company. So in other words, it could be a family limited partnership acting as a holding company, and it would own the LLC, which it still becomes a single member LLC, which gives you that operational advantage. Or it would be a Wyoming LLC or another strong state LLC, which would own the LLC that in turn owns the property. So it becomes a two-tiered structure, and that gives you significantly better liability protection than just owning it in your personal name.
Yeah, but Bob, if I own an LLC in a family limited partnership or limited partnership, okay, then they can't pierce that limited partnership to take its assets, right?
Well, that's right, because
the charging order against the income of which the general partner is in control of. Why don't you explain that?
Well, the general partner controls the limited partnership like a president of a corporation or a manager of an LLC. The limited partner has no liability whatsoever because they have no management authority. And so you would typically be the limited partner, and an entity, a corporation or LLC, would typically be the general partner to shield you from any kind of liability. And so if there were a slip and fall on the property, once again, they might be able to take just that one individual property, but the goal here is to make sure they cannot get at your personal assets. They cannot break through the structure to get to your personal assets. And that's called piercing the corporate veil. When we have those two tiers of structures, it becomes much more difficult, if not impossible, to pierce the veil and get at your personal assets.
All right. Now, what if I'm not married and I don't have any kids and nobody likes me? How can I have a limited partnership?
Well, you can have, you would be the limited partner, and a corporation that you own can be the general partner. So anybody can have a limited partnership, single or married.
Okay, so that LLC is not me. Therefore, we have two different entities. and then the creditor can't get the assets from that limited partnership. If they could get a charging order for an income, general partner doesn't distribute the income, and then creditor gets to pay taxes on money it didn't receive.
That's right.
They're
That's
not
correct.
going to get a charging order.
That is the beauty of a charging order.
Yeah. All right. So what we've just discussed, sir, is the basics of any structure as far as I'm concerned, and probably went over the heads of many of our viewers today, which is why I'm doing this probably for the 113th time. This discussion. I'm sure probably equal as many for you. I got to keep counting them in, folks, because it's so simple to do. Now, another thing, we don't want to have our rental properties mixed up with our flipper properties, largely for tax reasons and other reasons.
Mm-hmm.
LLC for our flippers and an LLC for our keepers. So remember, the LLCs don't own the properties. Land trusts own property. LLCs own land trust. And my flipper entity pays all the expenses, frankly, for acquiring all the properties, whether regardless of what entity they go into, and then all the other expenses, such as operating costs, legal fees, and anything else that does not involve that property directly with the tenant buyer. The whole goal is to make keep that flipper entity, make as little money as possible by paying everything we can out of it, pre-tax dollars, get that net income down, whether it be an LLC or a C, same thing. Now, LLC versus C is always a topic for discussion, but I don't know, we've got a little bit of time here today to get into it, but it's pretty simple. And I use both for my own reasons.
Mm-hmm.
Just that people use C Corps, mix them or what?
Well, yeah, a C corporation has its place, and it may be appropriate in a structure, may not be. It just depends on, once again, the individual. But typically, when we use a C corporation, it's because the person is self-employed, not a W-2 employee. Spouse is not a W-2 employee. Therefore, they're not getting health insurance through their employer. And as a result, with a C corporation, all medical expenses, all health insurance premiums are completely tax deductible with a medical reimbursement plan. And that only is available with a C corporation or an LLC taxed as a C corporation. Those are the same thing from a tax standpoint. So there are times and circumstances, but that is one of the most important distinctions of a C corporation. It provides health insurance benefits and health expense benefits.
Well, I'll tell you one of the most important things to me about it. Well, a couple actually. Its net operating income does not show on my personal tax returns because it has nothing to do with me personally.
Exactly. Yep.
One reason I have a couple of C's, I don't want to worry about that income affecting my situation. My personal tax bracket is way higher than a C right now. C is 21% since 18. Mine is 37%.
That's right.
Figure out, I'd rather have the C Corp make the money.
Right.
You have a 5.5% state tax on top of that. So it's a balancing act. You've got to make sure, and the C Corp has a different year in you choose. I have one that is January 31st, Bob. So I got that whole year to take any profit, figure out how to reduce the taxes on it. And then I got that whole, so next October after that, I actually have to pay the taxes.
Well, you're right. Yeah, these are some additional benefits of a C corporation. Very significant from a tax standpoint. It's the only type of entity that can have its own fiscal year other than December 31st. So you can pick and choose a fiscal year, hang on to your money, avoid paying taxes for a longer period of time. And also, as you mentioned, you can do tax arbitrage, it's a 21% tax rate at the moment. Let's hope it doesn't go up, but there are the proposals to make it go up, but let's hope it doesn't. You can have income, as you mentioned, Ron, very, very astutely, that income from a C corporation does not appear on your personal tax return. So there are a number of very important tax plays that you can do with a C corporation.
Of course, the downside is it's harder to get money out of a C.
Yeah, it is.
Because if I take it out of dividends, I'm not going to get it as a deduction, and yet I'm going to have to pay taxes on it personally, and that's double taxation.
That's right.
take money out of a C, Bob, without having to pay double taxes?
Well, that's pretty tough. Yeah, and the best thing we can do with a C corporation, depending upon how much income there is to make sure that you deduct as much as possible, pay as many expenses through that C corporation as possible, and get some very significant tax benefits, minimize the amount of income that is taxable, and therefore avoid as much double taxation as possible.
Yeah. So beyond that, of course, I could take it out as salary, but then I've got the employment taxes on it, so I'm still taxed on that part.
That's right.
What do you think about taking some out for consulting or something? If I don't have a salary, I can't. If I'm not taking the salary, what other ways can I take it out?
Well, I mean, you can have the C corporation pay royalties to other organizations you own. It may pay some type of royalty for use of intellectual property. For instance, maybe you have a talk or a presentation that you give on a regular basis that is owned by the C corporation, and every time you give that, you may have to pay a royalty fee or a presentation fee. There are lots of ways that we can move income out of a C corporation on a tax favored basis. In other words, using pre-tax dollars, as you mentioned, rather than paying with after-tax dollars. So the goal is we want to have the C corporation to take advantage of the tax benefits. We don't want to abuse it, but we want to use it correctly, and we want to be able to minimize the amount of taxable income in the C corporation, and then maximize the deductions that are available only through a C corporation.
And of course, as you said, the C corp can have a pension plan, and that contribution is tax deductible.
Yes, it is.
Which lowers it and puts the money over there where you can use it just like you use your self-directed IRA.
Yep, exactly.
Listen, we're out of time. You and I could talk for days.
It's fun talking to you, Ron, about this stuff. It's good. Yeah. I think, honest to goodness, folks, you know more about this, about asset protection, Ron, than most attorneys do.
Well, yeah. But at what price, Bob?
I understand.
I got to pay. They get to collect. I've never been in any kind of litigation where the attorneys didn't win. Don't get me started. I'll go on an attorney joke binge.
I won't.
Listen, Bob, do you want to give folks your contact information or not? Up to you.
Sure. It's you can reach me at bob@assetdefenseteam.com, or you can just call our number if you want to, and that's 855-502-7738. It's 855-50-ASSET. There you go.
All right, and if you're watching this and you are not already in our program on Planet Ron, then you can go to ronlegrand.com and get all the information you want, or you can go to the Mentor Podcast /terms and get an hour webinar on how we make so much money in terms business with so many thousands of our students around the country. Well, Bob, I appreciate you taking the time to spend with us today. You are a real asset to our folks and are working with a lot of our building their estate plan, don't you?
Yes. It's a slow go, but we're doing it.
Are they easy to work with, or are they hard to work with?
Oh, your students are great. Yep, they're awesome.
I don't need to get on them, huh?
Nope, you're good.
Right. Well, thank you, sir. Always a pleasure.
You bet. You bet.
Very soon.
Bye-bye.
That's all for this edition of the Mentor Podcast. To connect with Ron and learn how you can attain financial freedom, as well as up-to-date strategies to grow and protect your wealth based on today's discussion, go to www.connectwiththementor.com.